Hello, my name is Thane Rosenbaum, and I'm the creative director of the Forum on Life, Culture, and Society. We call ourselves FOLCS, and welcome to the FOLCS Conversation series. Tonight's guest, the author Ben Sheehan, with his new book. Are you ready for the title? OMG, WTF, Does the Constitution Actually Say? If you're anything like Ben Sheehan believes we are, we don't know very much about our Constitution. We'll walk around with a lot of civic ignorance. And if you're with us here for tonight, for the next hour, you're going to learn a lot. And it's an incredibly engaging book. It's a fun book to listen to and read. And he's going to be an enormously, and there it is. It's a cool looking cover. He's a nice guy. And we're going to have a really interesting conversation about the Constitution. And you're going to sound much smarter at the next dinner party if you're allowed to go to one in the near future. Before we get to talk to Ben, a couple sort of housekeeping moments here. If you want to leave a comment throughout the evening, you can go to the chat section and click on the chat button on both on the bottom or it's sometimes to the right of the screen. If you want to buy Ben's book, which I certainly hope you will, there will be a link for it. It's on the event page and also in the chat screen. If you would like CLE credit for tonight, because we are offering CLE credit for tonight, you can go find that in the chat section and I think also on the event screen. And if you if there's a financial hardship, we have a financial hardship policy and it's still not too late to register. Well, the only thing that matters is you stay with us for the entire hour. That's all we care about in order for you to receive CLE credit. One final thing, and we'll get to Ben. Look, this is our 5th event. We've been with you now for the entire length of the global pandemic. We're doing so as a public service, free of charge. However, we still have ongoing costs. Many of you have donated to FOLCS in the last 6 or 7 weeks. We're very grateful for that. Many of you have signed up as members. We're very grateful for that. So keep us in mind because we have you in mind. Because as you know, we're in the business of the life of the mind, and that did not change, that never stopped, simply because we had to stay home. We decided to develop a digital presence and an entire online agenda and programming, and here we are with Ben Sheehan. His book tour was completely shut down, and that's one of the reasons why we're particularly interested in hosting authors. Ben, say hello to our audience.
Hello, thank you so much for having me. It's an honor to be here.
Thrilled to have you, Ben. I'm sorry about my Facebook thing. Just popped up.
No worries.
It's you know, we have the green screen ready, we've got the light ready, and then Facebook popped up. Let's start. Look, it's a very engaging, interesting book. What I like about it is that it makes the Constitution accessible, I think, for the purposes of inspiring more civic engagement and participatory democracy. You say early on in the book that Americans have a deficient understanding of the Constitution, in part because we haven't really been trained in civics. So why is that? I'm just curious. I mean, and also explain the difference between learning history in school and learning civics in school.
Sure. So I guess I would compare civics to the recipe or the instruction manual, and history is the context. And we spend a lot of time in our schools learning about the context, the timeline of history. But we spend a lot less time today learning civics. And by civics, I mean the rights and responsibilities and the roles of being a citizen. And what I find really interesting about this is that civics and government education was a huge part of the impetus for our public education system. In 1796, George Washington used his final State of the Union address to implore Congress to create a national university dedicated to teaching people civics and government, because he wanted everyone to know how to run the government and participate in the government that he and his friends had just set up for everybody. And this was a huge part of education for a long time. And in the 1950s and 1960s, you had classes like American government, US history, foundations of democracy, civics. And then coming out of the 50s and 60s, you started to see those classes cut. And today, we only have 8 states that require a year of government or civics. And those cuts recently started in 2002, after that with No Child Left Behind, where there were all these federal incentives for schools to focus on reading and math, because depending on their scores, they were able to unlock more federal funding. And same with Common Core in 2010. So really, these civic education cuts happened after the 50s and 60s, but heavily in the last 20 years. And so my generation and the generation younger than me, Generation Z, we really didn't get a lot of this education or had classes devoted to it. It was sort of shoehorned into social studies, or it was, worked into US history. And that's not the fault of teachers. This is the fact that our states aren't requiring this of schools. So we sort of have this civic education crisis right now, where we aren't teaching young people the basic understanding of not just how the government is set up, but how they can participate in it.
So history, I suspect you're saying, if we're teaching history, we're just teaching them dates. We're not really teaching them about how to participate. They're saying, right, give us an example of like what we are learning versus what we should be learning, if we were to have a more functioning understanding of how the Constitution works.
Sure. Well, I think history and civics have to go hand in hand. So we spend a lot of time looking at, American history as a timeline from when it was founded, to the Declaration of Independence, all the way up through pivotal events in the last few hundred years. So I think the word in the book that I use is masturbatory. We seem to sort of be obsessed with history at the point of not teaching people how to participate in our government. And there is this sort of ideal mind and focus. I mean, think of, the pictures of the founding fathers and powdered wigs and sitting around the table and standing with raised fists and fingers pointing at each other. We have this sort of picture that we ascribe our history around, but much less of this focus is around telling people how they can get involved in government. And it goes beyond voting. How can you not just, vote when you're of legal age, but how do you make sure that once those people are in office, you can hold them accountable? And that means paying attention to the legislature. That means following your legislators, not just at the federal level, but the state and the local level with city and county councils. It means knowing who has the power to do what. If you want something to happen, it's almost like the 1-800 number, who do I call? Who do I follow? Who has the power to do that? And I think it's hard to see the change that you want to have happen and make that change if you don't know, who controls what. It's almost learning which lever to pull.
So Ben, we're not the only liberal democracy in the world. We do have, as you point out, the oldest constitution on the planet right now. But we're among other countries that are also have constitutions that were inspired by the enlightened philosophers of the Enlightenment. So let's think about some of these Western European countries. Do they do better than we do in civics education? Do they know more about their constitution than we about ours?
So the studies that I've seen have said that yes, they do seem to know more. I wouldn't say the United States is at near the bottom. We're sort of in the middle of the pack, maybe slightly above average. But what's a really interesting study is that in addition to that, the United States did test very high in being able to ingest facts about history and government through media and entertainment. So things like satirical news, things like everything from TV shows to podcasts to news, entertainment, movies, we have a better aptitude at being able to pull out facts and figures and information about how our government works from that media as compared to other countries. So while we may be more deficient in our understanding of civics, we're good at parsing it out from our media.
If there is one misconception that most people have, this is aside from the deficiencies that we're talking about, if it's just a fundamental misunderstanding about what our Constitution is and what it's supposed to achieve, is there one or a couple one thing that surprised you in your research that, anecdotally or the data shows that most people believe something that is just foundationally false?
I have so many answers to that question. I'll start with a couple. One is that I had always believed that we live in a country with three, and the word that's often used is co-equal branches of government. And what I learned by reading the Constitution over and over and writing this book is that checks and balances is not the same thing as equal branches of government or the even distribution of power. in the Constitution, there's a reason that Congress is the first article, the president is the second, the courts are the third, and that the first article for Congress is far and away the longest article in the Constitution, is that's where the power was centered. It was supposed to be centered and lay with the representatives of the people. And this makes a lot of sense, because if you think about who created the Constitution and where they were coming from and what the government in England was like, it makes sense. They wanted to avoid having power centered in one, unitary authoritarian, one executive that's passed down from generation to generation through the bloodline. This was taking it and giving it to the residents of the country, the people, via their ability to elect people to the state legislature, and then originally state legislators electing or choosing senators. People were able to vote for members of the House directly. So the idea that it's 3 even branches and it's distributed, a third, a third, a third in terms of power, in my view, is completely inaccurate. While checks and balances do exist and the branches check each other in different ways, it's not an even distribution of power. So that is definitely the biggest one. And that was a big surprise to me, because I think we so often focus on the president and the executive branch today. And part of that has to do with our media and how we cover campaigns and elections, also the courts as well. But I think part of that is because it's sexy to cover the president and campaigns and the horse race of who's up or down in what polls, but also because of gridlock and inaction in the legislature. It's sort of the president having to take matters into their own hands, and we saw that with Obama with executive orders. And executive orders aren't a new thing. I mean, this has been around, but we sort of, because of the dysfunction of Congress, we're looking to the other branches as almost a stopgap or a patch on the underlying problem, which is the inactivity of Congress for so many reasons. But I think that's part of why, between our media and our focusing on these other branches to make up for the inaction that Congress has, is giving us a warped understanding of the Constitution.
Ben, you touched on this a moment ago. It reminds me of something. I just recently published a book on the First Amendment on free speech. And I know I say in the book, and I've said on podcasts, that the founders of our nation were brain damaged by King George III. And in reading your book, I felt it even more so, because you end the book with the Declaration of Independence, which is interesting. You'd think you would have gone in the other direction. And it made me think, oh, I see what Ben is doing. He's showing us the Declaration of Independence, and then he's going to explain that and make that accessible too, as a way of explaining to why we just went through this book on the Constitution. The Bill of Rights, it just seems to me, is one after another an attack on King George III. Can we talk about this? Because I think this to me seems like a misunderstanding, that in many ways, these are not affirmative rights. They're more like negative immunities. It's government, you can't stop me from doing this. The government shall not. These are not, they don't sound like you have the right to. They're not written that way. They're not written, you have the right to. They're basically saying the government can't stop you from. And so it seems to me, I know that I've taught this for many years, that's the difference between an affirmative obligation versus a negative right. A negative right, just back off. You can't stop me. So can we talk a little about this? Because the Bill of Rights really straight up and down seems that this is the way we lived under King George III, and we are going to call for our independency. And in doing so, we are going to now live this way.
Absolutely. I mean, I think the not being able to take something away versus giving someone something is a really interesting and important discrepancy. Yeah, I mean, you're correct. We talk about, Congress can't ban a religion. Congress can't prevent, free press. Congress can't, stop you from petitioning for grievances and peaceably assembling. And you see that with, search and seizure laws. These are rights that, again, to your point, this is what was happening in English. That this is very much created as a response. And the Bill of Rights specifically, when James Madison wrote it, it was, to help get the Constitution over the line. because people were worried that it gave the federal government too much power. And so the idea was that he would create these amendments, enumerating some specific rights so that he could get the extra ratification votes he needed to get the Constitution over the line. And in addition to the things not being able to be taken away by the government in the Bill of Rights, we also see this in the rest of the amendments, and specifically with voting. It's so interesting to me that the Constitution doesn't say specifically who can and can't vote. It does say that your right to vote, if you are a citizen, cannot be taken away based on your race, based on being 18 and over, based on your sex. Again, to your point, it's not granting someone the permission to do something, but preventing it from being taken away based on this. And I think that has to do with with the Bill of Rights, exactly like you said, a response to the British Crown. But for voting, it's really interesting because so much of this was punted to the states, and that's another big takeaway that I had from reading the Constitution and writing this book. Is knowing the limits on the federal government and where it ends and where the states begin. And that's such a huge amount of power at the state and local level. And I think that we forget sometimes, because we're so focused on the federal government, how much power state governments and localities have, because in part it has to do with our national media. We're so focused on national media. We're so focused on the federal government. It takes us so much oxygen. But in reality, it was designed to be limited, and for the exact reasons you said.
So you said this a moment ago about Madison. I'm going to have two questions about him. In terms of, the first one goes to the idea about, well, that's why he added these amendments, right? One of the things I think that is complicated for people when they think about the Constitution is that if you read, say, for instance, the First Amendment, it's packed with an incredible amount of stuff in one sentence. Right? I mean, think about, in the First Amendment, there's freedom of religion, there's freedom of press, there's freedom of speech, there's freedom of assembly. Are you kidding me? You can't even divide that up into 4 amendments? That's all in one amendment? By doing it that way, Ben, it always seems to me that it just left open an invitation to not knowing what the hell's going on, right? It's like Madison said, you know what? We're going to let the future figure this out. I'm not going to tell you what speech means. I'm just going to say you have freedom of speech. I'm not going to tell you the ways that the government can interfere in your religion. I'm just going to say they shouldn't do that. They can't establish themselves. I don't know what assembly looks like. I'm not going to tell you. I'm just going to say the government can't stop you from assembling. So I think that, it's as if the founding fathers set us up. I mean, they set us up, let's be honest, to make us crazy. Right? They're laughing in their graves. We made them insane. What we did is then we empowered a Supreme Court to figure out every few years what it means, even in very small changes, incremental changes, because no one really spelled it out in the very instance. I think that that's also one of the things that's most difficult when we think about our Constitution, that it doesn't have a lot of clarity. It has these very strong aspirations, and then it's basically saying, and you figure it out.
Yeah, it is very vague, and that vagueness is the source of a lot of dispute. For the First Amendment specifically, what's interesting is that Madison originally wrote 19 amendments, and then it was whittled down to 12, and they sent 12 to the states, and they ratified 10, obviously. And in the very earliest draft of the Bill of Rights, the First Amendment, there are all, like you said, there are all these rights in it. They were actually different amendments, and they were combined. So yeah. they were all thrown into one. But the vague language is the source of so much anxiety, and I think it gets back to the ability to change the Constitution that we have. This idea that when things are in dispute or not clear, that we have to sift through and parse it out and stretch the meaning of words and we have to stick to what was originally written, in my opinion, is not true. If it was true, then we wouldn't have Article 5. We wouldn't have the ability to change and amend the Constitution. So I think what we've done over the years, and part of it has to do with polarization, Part of it has to do with, federal versus state, and just the sheer, difficulty of having amendments get proposed and ratified. But we've taken to trying to stretch the meaning and interpret the amendments as written and the articles as written to an extreme extent versus passing an amendment to change it. And this is something that used to be a lot more common. I think all the time back to the fact that in a 10-year span, from 1961 to 1971, you had 4 constitutional amendments. I mean, the idea to think that since 2010, we could have had 4 constitutional amendments is
I'm
kind
not
of
sure
strange
people
idea.
believe you can do that. I mean, most people, if you ask them, right, do you think that there is there language in the Constitution that allows you to add on to it? I suspect most people would say, no, it's pretty much the way it is right now. You really can't mess with it. It's like sacrosanct.
Right. And what I would, to those people, I would say they should look at the conversation between James Madison and Thomas Jefferson right around the date of ratification and when the Constitution went into effect, because Thomas Jefferson, and while I'm fairly critical of him in the book for other reasons, the interesting thing about him is that he thought that the Constitution should be changed every 19 years. He compared the Constitution to, existing in its current form forever, as if you expected a coat you wore as a child to fit you 19 years later as an adult. This is something that they expected to be changed, and how often was a matter of debate, but it was never an idea that, the way it was written in 1787 would last forever. So this is the push and pull of, because we're so polarized right now, because it's hard to get 3/4 of states to ratify something, even getting 2/3 of Congress to propose something is incredibly difficult. So it's because we're having trouble getting the consensus necessary for amendments that it's left us to try to, bend and pull and parse meaning out of the text as it is.
So then how do we account for this debate that you hear in law schools, Senate confirmation hearings for Supreme Court justices, between the originalism school versus a school that we could call the living document school, right? Which you essentially just hinted at a moment ago, right? Conservatives say, well, you can only, the Constitution says what it says. And you and I just discussed 5 minutes ago that it doesn't even say very much. That's the problem, right? But arch conservatives, when they come to originalism, they say, oh, no. If it's not in the Constitution, then, for instance, abortion, there's no abortion rights in the Constitution. Now, we know that comes out of the penumbras. Believe me, we know this was really controversial stuff, even to this day in law schools, about how it was that the Supreme Court, either invented or intuited these unenumerated rights like contraception, abortion rights, homosexuality relations, marriage equality, right? Think about all these things that conservatives will say, where in the Constitution do you see this thing about, right to marriage? Where do you see that? And those who have been in the more socially progressive schools say, well, there are enumerated rights. It comes out of the 14th Amendment. It comes out of the 9th Amendment. This is an ongoing debate that simply doesn't seem to be reconciled. Can you talk about it, explain it? What you just said a moment ago suggests that Jefferson and Madison understood that, or is it Hamilton? I can't remember which one you said. Madison understood that this is what was going to happen, that it was going, the document would be, and there would be changes made, amendments would be made, a fuller understanding of what rights mean would be made. And yet somehow we can't find a way to reconcile those two different philosophical underpinnings of constitutional analysis.
Yeah, well, I mean, it's kind of, in my opinion, it sort of says it all in the Ninth Amendment, and this is the brilliant design in the Bill of Rights that James Madison came up with, is that just because it isn't listed in here doesn't mean you don't have it, and it doesn't mean that what isn't here can be used to deny you that right. And there are all sorts of things, like you mentioned, right to privacy, right to marriage, all these unenumerated rights that the courts have decided that people have. Originalism, I find, and it's not, I would say I would have two categories for this. One, originalism, the Antonin Scalia school of thought, and textualism, which is something that Neil Gorsuch has talked a lot about. Originalism, I would go back to my idea that if they wanted it to stay this way, they wouldn't have given us the ability to amend it. What I do think is interesting with originalism is just trying to get in the mindset. And one amendment that comes to mind, specifically for originalism is with the 14th Amendment, and equal protection of the laws. And because we look at this in the context of it being passed right after the Civil War ending and extending rights specifically to former slaves and African Americans and equal protection of the laws, but that has been used in the years since. The court has not held different classes of people to the same protections, and that's why we have these different suspect classes versus quasi-suspect classes, and strict scrutiny versus intermediate scrutiny and rational basis. And you're looking at it through the originalist context and saying, well, they intended it to protect these people, so it's not going to be used to protect other groups of people that they didn't have in mind as much. Textualism, oddly enough, I think is a little bit more progressive, and there's a case that I'm really, watching and curious to see what happens with the Supreme Court around whether or not Title VII of the Civil Rights Act and the word sex is used to protect people based on sexual orientation and transgender status. And I don't want to predict or be in the business of predicting or thinking how I'm going to guess how certain justices are going to rule. But I think that it's interesting that, you have somebody who's conservative like Neil Gorsuch, seeming to ask a lot of questions and talking a lot about the fact that this might include transgender status and sexual orientation, and, looking at really the words above the context. But I do think that the obsession with originalism, the obsession with textualism, it does feel like there is this argument being made that things are just supposed to stay the way that they are. And I do think, to your point earlier, that there is this miseducation that things are supposed to stay the way it are, and that was the intent. And I think that disinformation is being promoted by people who don't want things to change. And why don't they want things to change? Because they like the way it is. They like the power they're able to continue having, the voice they're able to have in government. You wonder why certain things that are supported by a vast majority of Americans don't even get, a debate on the floor of Congress. And it's because we have this whole system where people are able to continue holding their jobs, and this gets into campaign finance and it gets into gerrymandering, but it's not representative. So you are sort of left with this weird, broken system where our voices aren't being heard, and these originalism or textualist interpretations are really more of a proxy. At best case scenario, it is understanding the intent, looking at the words on paper. But worst case scenario, it is a proxy for trying to, maintain a lopsided power structure.
So can we talk a little about Madison? You think he was shafted, right? This is the man who is the author of the Constitution, a two-term president, and people don't know him. He does not have a musical on Broadway in his name.
Yeah, he definitely got the short end of the stick. My own personal theories, he's the shortest president we ever had, 5'4". He, doesn't look great in his portraits, didn't land on money that's still in circulation today. Doesn't get a memorial. He gets, a library, a memorial sort of inside one wing of the Library of Congress. But I think he absolutely got shafted, and his notes, that were, so crucial throughout the Constitutional Convention. He wrote the Bill of Rights. He was also Secretary of State under Thomas Jefferson. He was a U.S. representative. He was the Virginia delegate. He had such a hand in creating our government, and yet he isn't, in the top tier of the George Washingtons and Thomas Jeffersons and Benjamin Franklins, at first thought. And I think I really don't entirely know why, but he strikes me as somebody who put in the work and did the hard work. And there were people who were maybe more showy or were able to take credit for it. But he was somebody that you can kind of look at all these different moments in early American history who was there behind the scenes and having a heavy hand in it that didn't get as much credit I think he deserved. And that's why he's on the cover of this book.
Let's talk a little about the politics of the court and how that plays into constitutional interpretation. I also think that this is an area that makes it difficult for people to really want to invest their time and emotion in the Constitution. For instance, isn't the Constitution say what it's supposed to say? Why should it change, right, based on who's on the court? Why are these confirmation battles so urgent, so important? Why do we only seem to know about opinions that are decided 5-4, right? Today, all we hear is 5-4, 5-4. The word swing vote, everyone knows. They don't know, maybe don't know what's in the Constitution, but they heard the idea of a swing vote on the Supreme Court. This can't be good for constitutional consensus. If decisions have to be 5-4, that essentially is saying that we really don't know. And that if Kennedy is off the court and Kavanaugh is now on the court, oh, well, now it's a different 5-4. And now Roberts becomes the swing vote. I think most people would be surprised to learn that I think for the first 100 years or more of the United States, the decisions were always 9-0, right? 8-1, that's really what this should be, right? I mean, because otherwise people lose confidence. Like, don't you guys and women know what this is about? Don't you understand the law? Why was it last time you said it was constitutional, and now you've carved something out that looks like you're saying that it's not constitutional? And why should it make a difference who's on the court, right? As long as they're qualified, right? As long as they're, by the way, that's an interesting question too, which we'll get to in a moment. Mm-hmm. But I wonder, you know, and also people feel a cynicism, right? Bush versus Gore is an example of, well, that seems like a cynical, is that really about the Constitution? Even more recently, cases dealing with Obamacare, right? Cases that are really before the Supreme Court right now that seem to be trying to undo Obamacare. Well, we learned that in the 2016 election, that's what future President Trump said he was going to do, right? So now we're seeing the federal undoing of Obamacare, and we're seeing that and saying, well, wait, if the Supreme Court is participating in that, isn't that more of a political decision than a legal one?
Yeah, it goes back to the roots of judicial review, and going back to one of your earlier questions, one of the things that people might be pretty surprised to find out that isn't in the Constitution is the Supreme Court's ability to strike down a law if it thinks it's unconstitutional, and this weapon has been wielded by a 5-4 court, and with the ultimate agenda of being able to overturn Roe versus Wade, to take away the Affordable Care Act. The suit that's being brought now among attorneys general, the idea that because without the individual mandate, the whole law has to go is pretty thin legal ground, I think, and a lot of legal experts would agree. But the politicization of the court, I think, reflects just the larger politicization in our society, and it is increasingly hard to look at anything not through a partisan lens. And I think that, yes, of course, this is going to affect the courts. And this isn't to say that the courts didn't used to be, non-partisan, but this is not something that is specific to the Supreme Court. It's all throughout our federal judiciary. And you look at the types of people that are being nominated and confirmed, younger, very conservative. I mean, the appellate courts today are, 30%, at least, if not a full third, of the judges on the circuit courts are Trump nominations and Mitch McConnell Senate confirmations. So it is very much, a party using the courts as a political weapon. And I think it also gets back to the fact that, there's so much inactivity in Congress, and using the courts as a way to create lasting change and strike this down. The thing that keeps coming up in my discussions with a lot of these events is, we aren't fixed at 9 justices. Congress could pass a law to change this tomorrow, and we haven't always had 9 justices. So that gets back to another thing that people think is in the Constitution that isn't. But I think to your question, it is the courts becoming such a partisan tool gets back to the fact that we just live in a divided society. And I could go into why I think that is, from our news media to our social media. In the last 10 to 15 years, getting our diet, whether even if it's through traditional articles and publications, coming to us through social media, it is a warped lens. It is not the same set of facts that I get necessarily that you get, that my uncle gets. And if we're ingesting different realities, then we're going to have vastly different opinions, because we don't even have the same set of facts to start from. So I think in short, the court partisanship is just emblematic of the larger problem, I think, in our society, where it's getting increasingly impossible to look at anything through, without a red, tinted pair of glasses, or a blue tinted pair of glasses.
Here's another area I think that comes up that's confusing to people. It's certainly confusing to me. I just wrote a book about this idea of when constitutional rights collide with each other, right? My right to this versus your right to something else, right? The founding fathers didn't tell us who gets to win. Tie goes to the runner. How do you know how to make a decision? In my recent book, I talk about the weaponization of free speech that basically tramples over the rights of other people who just want to live their lives without being insulted, humiliated, treated to indignity, and trashed in the public sphere, right? And Hal says, well, but I have a right to free speech and the government can't stop me from doing it. So you go, do you really think that that's what George Washington thought, right? That you could just, for instance, burn a flag of the United States in front of a family whose son just died serving his country? The General George Washington actually thought, when he was signing off on the Constitutional and the Constitutional Convention, that that's what it meant, right? I don't think he did, by the way. I don't think that's what he meant. I really think he would be appalled at, like, for instance, Snyder versus Phelps, right? The disruption of military funerals by a church group in Kansas that is opposed to gays serving in the military. So as you know, they travel around the country and they disrupt military funerals by holding up signs that say, God hates fags. And I always think to myself, George Washington thinks that's okay? That people, and these, by the way, these soldiers aren't even gay, not that it matters. It's just that they served in the military and they're dead, and this church group is opposed to homosexuals serving in the military. And this is how they express it, because they have a First Amendment right to peaceful assembly and right to free speech. But there are many examples, say, for instance, religious freedom, impinges on the privacy rights. For instance, that master cake case, one of my favorites of recent years, the Colorado baker who refused to bake a cake for 2 men who were having a same-sex marriage. And he's saying, look, I have a First Amendment right, not only to my religious beliefs, but on top of that, I'm an artist. These are really good cakes. And I'm not just a regular cake maker. You can't make me express myself in this way. Those are really colliding liberties. We see this, I think, right now in front of the Supreme Court, or I think it either decided or it was just recently argued about Obamacare and rights to women to receive contraception, right? Very good example. The Obamacare says women insurance companies have to make those services available to women. But if you're a religious employer, you can raise your religious objection. Even if you're a private employer, small family, saying, look, we're opposed to abortion and contraception, and we don't want our insurance company to pay for that. So there's an example of something we're seeing more and more of. I think that what we're seeing in chipping away at Roe v. Wade is more this. Like, it's what people should worry about with abortion is not the withdrawal, the reversal of Roe v. Wade. It's the chipping away at the rights. I don't think most people understand this, but this is interesting and is definitely becoming much more part of our constitutional framework. Can you talk a little about that?
Sure. Well, I'll talk about it with regard to parts of the First Amendment, and then with regard to parts of the Fifth and the 14th.
In fact, didn't you just have a tweet I just saw the other day about freedom of the press and freedom of assembly, both things colliding?
Yeah, well, the key word is peaceably. Right to peaceable, to assemble peaceably. And I would argue that showing up with an AR-15 and trying to break into a legislative meeting to confront legislators, it would, in my definition, isn't peaceably. Other people may have a different definition, but I think you see rights sort of pitted against each other all the time. And one example that's come up recently is people being asked to socially distance when they go to houses of worship, and that shrinking the amount of people that can fit in a church. Asking people to sit 6 feet apart isn't banning your exercise of religion, and we have precedent for there being small caveats and small limitations on free speech. That's why we have slander laws and libel laws, and you can't run and yell fire in a crowded theater. Like, there are places where it is limited, but it's not banned. You're not banning people's ability to speak their mind. You're not banning somebody's ability to exercise their religion. And where it gets really odd and strange is with specifically the coronavirus and, the statewide stay-at-home orders, calling into question, the life, liberty, and property. And you're sort of in this weird scenario where people's ability to move about freely, their liberty and earn a living for themselves, which can be construed as property, is directly at odds and threatening people's lives. It's their sheer ability to move about and spread this disease. So you have this sort of life versus liberty and property. And I think there's a reason that both in the Fifth and the 14th Amendment, those three things are listed in that order, starting with life and then liberty and then property. But the idea that there are zero limitations on any of our rights, again, is not true.
Although it's conflicted, as you were describing the peaceable assembly. I couldn't help but think of something I actually wrote about and was criticized for many, many years ago, the Ground Zero Mosque. That was a very loaded issue, right? For those people who don't remember, there was supposed to be, at the time that before they built the Freedom Tower and a memorial for 9/11, someone had purchased some property literally around the corner from what would then be what is now the 9/11 Memorial Museum. And they wanted to have a sort of a social gathering for Muslims that would also include a mosque. And the families of 9/11 said, not here, right? And even Mayor Bloomberg said, what are you kidding? The First Amendment gives you the right to express your religion. I happen to be one of those. I said, yeah, but that's not saying that you can't have a mosque in Manhattan. There are lots of mosques in Manhattan. There could be as many, but do the families there have some rights under the Constitution? The question there was no. They had no rights under the Constitution to disrupt the rights of putting a mosque in an area that really trampled over some really profound sensitivities at that time. So there are so many different examples of the collision of rights. And sometimes it goes to the point that you're saying, we're not saying you can't do this, we're just saying it may be somewhere else, right? And this is even the problem with, what I described in Snyder versus FOLCS, right? It's not that you can't object to gays serving in the military, but do you have to actually get a permit to disrupt a military funeral, right? Must neo-Nazis march in a town of Holocaust survivors? Really? Right there? There's nowhere else for them to go? They can't write an op-ed. They have to do it in this way. So I think that this is something that is still ongoingly confusing for most people, the conflicts and the collision of rights. Let's get to some interesting little anecdotal things that you have in your book. Let's say Article 1, Congress has the power to declare war. And yet you say, with respect to recent wars,
we haven't declared a war. Congress hasn't declared a war since World War II. It's authorized wars. There's nothing about Congress being able to authorize a war and not declare it. But we've been entering all these military conflicts, and I have my own suspicions and hunches and ideas of why that might be. It can be very lucrative for certain businesses, and a way to certainly make a lot of more money. War is very profitable, but I find it odd that we're entering all these conflicts without an actual declaration of war, and I don't think a lot of people realize that.
Second Amendment, you actually weigh in a little. You say very modestly, "Hey, I'm no law professor." And before I get to that, I want to get to this other thing that I was reminded before. It's something that's been bothering me for years, Ben. Let me share this with you. There is no rule, and you point this out in the book, that a Supreme Court justice, first of all, not only doesn't have to be a judge, there's no rule that he or she has to go to law school.
Yeah.
Anybody, like for instance, like I've always wondered, nowadays it seems that unless you are a judge on the DC Circuit Court of Appeals, the highest of the circuit courts, because half of the justices right now, I think more than half might be from the DC Circuit, and every single one of them was an appellate judge on a major court, right? None of them were state court judges. None of them, there was a time when we had former governors, former presidents. President Taft became a Supreme Court justice. We used to have a more open understanding of, just because you weren't serving as an appellate judge, I don't even understand, why can't a novelist serve? I mean, why can't the highest court in the land have people that represent more than just judicial scholars, constitutional scholars? No one has this conversation. We don't even consider it. When it comes to the confirmation hearing, you always hear the same thing. We want someone who went to Harvard or Yale Law School and someone who is an appellate judge, right? And that's, even President Trump said that. You never hear a president say, "You know what I'm thinking? An NFL quarterback." That's what I'm thinking. And a former NFL quarterback, Joe Montana, should say, you'd never hear such a thing. And the founding fathers left that open. They could have made a requirement, and they said, "No, we'll leave it up to you."
Well, I think, you're sort of getting to the entire reason I wrote this book, is that for so long we've treated the Constitution as something that is reserved for lawyers. And if you're going to be arguing in defense or opposition to it in a court of law, it probably helps to have a law degree, but just understanding the basics of what it says should not be reserved to judges and law professors and lawyers. This is something that was created for us. And I would say that I would point out the fact that, about a third of the people who wrote the Constitution had no formal legal training whatsoever.
Exactly.
So, if the people who wrote it didn't go to law school and had no formal legal training, then certainly we have the right to understand it without formal legal training. But there, it's interesting because it's not even just Supreme Court justices that there are absolutely no requirements for in the Constitution. The Speaker of the House could literally be anybody. There's no specific requirements there. The President pro tempore, there are no requirements there. So I think it would be really interesting to have somebody who has a bit of a different background, didn't all come from the same circuit courts, didn't all go to the same schools. And, the reason we have Senate confirmation for judges is, to have a bit of a check on who these nominees are, that they couldn't be, just random loyalists to the president and buddies of his or hers. But this is, the sort of the point of this book, getting to to what you mentioned, is I'm not trying to raise the ceiling on expertise with this book. I am trying to lift up the floor, because I really believe it is much lower than we even realize, and that we would have a more healthy democracy and healthy society and healthy citizenry if we did understand this. And I think maybe there's some weird solace in a way of knowing that anybody watching this right now could, if they got, nominated and confirmed, could be on the Supreme Court. The House could pick anyone watching as their Speaker of the House. The Senate could pick anyone watching as the President pro tempore. There are all these sort of strange loopholes. And, I dismiss the idea that this wasn't by design or they forgot to include it, because there are so many other qualifications that they went to painstaking extent to include. One that's come up recently is, do people have the ability to be president for longer than 2 terms, rather being elected? And throughout the amendment, the 22nd Amendment, you can only be elected to 2 terms, but they mentioned holding office. If they only wanted people to hold office for 2 terms, they would have said you can't hold office for 2 terms, but they used the word elected. So I think going back and realizing these nuances is fascinating, and I agree with you. I think we should have more representation on the Supreme Court and some diversity. Obviously, you need to have an idea of previous case law. You need to understand what has been ruled before and precedent, which is why we focus on these legal experts. But yeah, I'd love to see Joe Montana on the Supreme Court. Maybe not him, somebody like him, but just to get a bit of a different perspective, because you can fall into a sort of hive mind with having a group of people from the same legal and educational background.
By the way, I mean, this is one of the reasons why the Supreme Court, although now the cases or arguments are being broadcast, the audio, for the first time in its history, historically, and even in a more recent era, justices have been opposed to having cameras in the courtroom. And there are a lot of people like myself who always thought, well, why not? Why can't America watch what's happening? Now, if you ask the justices, they'll say, well, that's because the American people wouldn't understand what they're looking at, right? Well, that is actually an example of the problem, right? That in fact, the arguments are done in such a way that you really wouldn't understand. They may be correct that they're saying, well, it would be useless for them to watch. And it would be interesting to see when this term is over, whether Americans actually did listen to the audio and whether they liked it, whether they learned something, whether they would like to see it continue. My guess is the court will discontinue it. That's my guess, because they have been, I once did an event for folks with, several times actually, with Supreme Court Justice Sonia Sotomayor, and I put her on the spot on our stage. When she was not on the court, she said she believed that there should be cameras in the courtroom, that America should see it. When she got on the court, she changed her mind. And then she literally said, well, I understand. There's a contradiction there, but honestly, Thane, the more I see what we do on the court, I just think it's more confusing than clarifying. Yeah.
No, I think to that I would say, well, I agree there should be cameras on the Supreme Court. I would also ask the question: who pays the salaries of Supreme Court justices? Who votes for the people who then give them their jobs? As tax-paying citizens, we pay their salaries, we pay their benefits, we pay their expenses, and you would never, if someone at a private company. If you were the boss somewhere and your employee was like, you get to pay my salaries, benefits, and expenses, but you can't watch me do the job at all. You can't have any window into how I'm conducting it. You probably wouldn't hire that person, or you would think it was extremely strange. And especially if they came back at you and said, well, you wouldn't understand what I'm doing. I think we have to get back to the idea that we pay for this government. This government is set up in the Constitution to work for us through representatives. And you would never run a private company with, a person at the top who's the boss of a lot of people at the bottom, who, makes the hiring decisions, pays salaries, benefits, expenses, decide if every few years that they want to re-up the contract. If you barely paid attention during the hiring process, you paid the salaries, benefits, and expenses, and then didn't really pay attention to the job, and every 2, 4, 6 years, you kind of check in and, maybe just re-up them because why not? And this gets back to what I think is the root problem of all this is a lack of understanding of the Constitution and civic education. Because if you're not educated on how to be a boss, then you're probably going to be a pretty bad one.
Right.
So I agree with you. We should have, let the American people decide if they're bored and confused by the proceedings. Don't make that decision for them.
The Electoral College, it shows up both in the articles and in the amendments. You point this out. Obviously, the Electoral College was very important to the Founding Fathers. Clearly, it has messed with us lately. Many Americans have been saying, hey, how many elections have been decided by the Electoral College, including our last presidential election, and not by the national popular vote? What is it that the Founding Fathers, what is it that they felt so strongly in the Electoral College that they put us in this situation that we're locked in to a situation where we have things called swing states, and that Iowa and New Hampshire are really important, and Ohio is super important? I mean, as you point out in your book, I love this, you said, well, if it was based on the national popular vote, the candidates would spend all their time in New York City, LA, and Chicago. They would go nowhere. They wouldn't go to Iowa. And it just seems like something is not right. I mean, although you point out that the fact that Iowa gets to go first is a boondoggle for the state. It really draws an enormous amount of money simply because their state legislature, so let's go first. We're going to go first. But it is seen twisted, right? This is a big country, and the popular vote isn't going to determine who is ultimately leading the country, and that the people aren't ultimately making the decision, right? It's really the electors of states that are, you know, ideologically in a strategic spot to in a position to deliver the votes in order to win the electoral vote.
Well, I think it goes back to, you know, the fact of the population discrepancy between when the Constitution was written and today. In the Constitution, you know, every 30,000 people corresponded to one U.S. representative. Today, it's about 760,000 people for one U.S. representative because we capped it in 1929 with the Reapportionment Act. So that created this massive, you know, lopsided population. And, you know, today you have millions and millions of people in one state. And, you know, in Wyoming, you've got 550,000. You know, the example that I bring up in the book is comparing Texas to Wyoming.
Right.
In Texas, you know, if you were to look at the voting age population and you were to divide that by the number of the electoral votes the state gets, you'd have about one electoral vote for every 550,000 voting age people. If you did that for Wyoming, you'd have one electoral vote for every 140,000 voting age people. So by that logic, your vote is, you know, has 75% less power in Texas than it does in Wyoming. I think because of the state populations being so lopsided, the fact that we capped, you know, the number of representatives in the House, so now representatives represent so many more people, this created this massive imbalance. So I mean, personally, I would, you know, do away with the Electoral College. I support a national popular vote. I also think it's interesting
now,
that—
but Ben, that would require an amendment. What would happen in order for that to happen? Just give us a civics lesson.
Sure.
Tell us what we would need to do to get what Ben just said. I'm sure many folks, listeners, watchers are saying, yeah, Ben, you go, man. Tell us how to do that. If we wanted to do it, what would it require?
It would require one of two things. So there's one obvious answer and there's one sort of workaround. The obvious answer is it would require a constitutional amendment to change how the Electoral College works or abolish it altogether. That is full stop. That's the obvious answer. The workaround is something called the National Popular Vote Interstate Compact. And what this is an agreement between states saying that because states have the power to, you know, decide how they choose electors, us not having the constitutional right to vote for president is back to an earlier question, something a lot of people probably would be surprised to learn, that they don't have the right to vote for president as an individual, as a citizen. You know, if your state lets you help choose the electors through a popular vote, that's how it happens. But that's only been the case for every state since 1880. For the first 100 years of this country, a lot of states, the state legislators just pick the electors. And I think so this is a workaround. It's short of a constitutional amendment. But what happens in the National Popular Vote Interstate Compact is that you have a number of states who decide, well, we're going to award our electors to the winner of the national popular vote rather than the winner of the popular vote in our state. But they've agreed to have this only go into effect if the states that sign on total 270 or more.
I see.
So right now you have about 15 states that have agreed to do this. And I think the total is around 190, maybe 197, something like that, electoral votes. So they'd still need 70 to 80 more electoral votes for this to take effect. But if you get enough states to sign on, then they all agree to award their electors to the winner of the national popular vote, not their state's popular vote. And you could circumvent the Electoral College that way.
That's how you would get there.
That's how you would get there.
Better represent the popular vote.
Exactly.
By actually deploying the Electoral College to do the work, right? It's essentially, it's forcing the Electoral College to mirror, to mimic the popular vote.
Right, and you would most certainly get a legal challenge on that. And
Right.
there is, part of the Constitution says that states can't make, compacts with each other. I think a lot of this was intended to prevent states from aligning each other, defense forces wise. Oklahoma and Texas can't get together and create Texahoma and invade Nebraska. I mean, this is sort of what they meant by compacts, and I think the language around other states not being able to join up and create a confederacy reflects that. But this is something that would happen, but yeah, would get a legal challenge, and then it would go up to the Supreme Court.
All right, one last question, and we'll say goodnight to Ben and have some final words. So you raised something that I've been thinking about and actually reporting for the last year or so for CBS News Radio, executive orders. Because you point out at the end, there's some things that we do, like you say, lobbying is one area. I guess the influence of money in elections is another area. Political parties, right? The founding fathers didn't know there were going to be political parties. But in fact, gerrymandering today, partisan gerrymandering is legal in ways that racial gerrymandering is not. So there's an area where the Supreme Court is not in alignment. They're saying if the winning party in a state legislature wants to change the voting districts to favor themselves, they're allowed to do that. If they want to do it to deprive African Americans from voting, they can't do that. And the question is, what? Why? I thought the idea is that you shouldn't be messing around with the districts, right? You shouldn't be trying to rig the system in your favor. It shouldn't just be because you can't discriminate against a person, but you can discriminate, you can favor yourself if you're a Democrat and you happen to win the state house. So you talk about a number of these things. They're very important ideas in your book. I just want you to talk to this one idea, executive orders. Why? It's come up a lot in the Trump administration. Comes up a lot. Build a wall. Well, the cost of a wall is determined by Congress. They have the power of the purse. If you're going to build stuff, appropriations, Congress makes that decision. If you issue an executive order, right, that seems to be a workaround, a go-around, a reverse play to allow the president to serve as his own legislature, right? And to issue something, is the executive order concept in the Constitution? The very fact that what I don't like about it is apparently, you correct me if I'm wrong, if I issue an executive order, the person who gets elected the next time can completely undo it. He goes, never mind, I don't like that one, right? So something that actually abrogates the rights of Congress in terms of the balance of power, right? The division of responsibility. You can work around that by not doing anything, but by simply issuing something that has nothing to do with one's constitutional authority.
So executive orders are not in the Constitution. However, they are constitutional as long as the president is enforcing an existing law and using executive orders to help enforce that law. There have been presidents who have used a lot of executive orders. FDR issued the most executive orders. Teddy Roosevelt issued a ton of executive orders. And we've seen this as politicized in the presidency of Obama and Trump. And yeah, this is something that is not mentioned in the Constitution. It is part of the president's job to, by the way, execute the laws in good faith, meaning following the laws and executing them. Whether or not you agree with them, you still have to enforce them.
Right, and by the way, just to be clear, it may be a good thing, right? You might actually tell our folks audience, by the way, over the long term, we can point to some executive orders that managed to achieve something that would have never happened if not for the executive order. But in doing so, again, if you're trying to understand how our government works from perspective of civics and what's constitutionally authorized, the executive order is a glitch. It just seems like, what is it? It's like a what is it, like a joker? Yeah, joker in a deck of cards, right? Like you get to pull this thing out for what? Just because you want to work around the constitutional authority.
Well, it's both a matter. I mean, yes, in one regard, it can be working around a constitutional authority, and to your point, yes, the next president can overturn an executive order, so it's not a lasting thing. But I think it gets back to my earlier point of, you know, on one hand, executive orders can be used to do something that you're angry Congress isn't doing, or you're trying to overexert your power. So yes, they can be attempted to be wielded in an, you know, authoritarian way. But also, you know, I would point to executive orders around, you know, the environment or something else for the welfare of the country, as something. If, you know, Congress isn't doing its job, you know, how else do you get things done? And I'm not saying that, you know, going around Congress is a good thing, but I think that executive orders in a way are like a Band-Aid on a broken arm. It's like, you know, they're a temporary solution and not even necessarily an accurate one. But the much larger problem is the broken arm, and the broken arm is Congress. Like, Congress is not getting shit done, and they are, you know, not agreeing on certain things. They're not coming to a consensus on things. It is so bitterly ugly and divided, and things that would make sense to us, you know, regardless of political party, and used to make sense to the other party, are now huge battles and disagreements. So on one hand, yes, executive orders can be wielded in an unconstitutional way. They can be wielded in a constitutional way, but also it's masking the larger problem, which is Congress not being able to do its job because of things you mentioned, gerrymandering and campaign finance and lobbying, and being beholden to the people who write checks rather than the people who cast votes. These are the underlying problems that we don't identify and don't fix. And so we're trying to kind of come up with these short-term solutions that, you know, aren't very long-lasting.
Wonderful, Ben. Really, you've been an amazing guest for us. Thanks so much. Before we say goodnight to Ben, a couple of last announcements. First of all, if you want to buy Ben's book, again, go to the chat section. There's a link there to buy his book. It's also on the event page. If you're looking for CLE credit, same thing, chat section, also on the event page. If you want to help support FOLCS, given the fact that we're still here, not charging as a public service, please become a member, donate generously at folks.org/donate. Let me just tell you a little about our upcoming events. The one that's coming up most soonest is on June 3rd. It's another one of the second installment of, there it is, of our FOLCS conversations on essential cinema. It's on June 3rd. It features the first Sidney Lumet feature film, 12 Angry Men, and I'll be in discussion with an award-winning actor, Matthew Modine. Many of you know him from Stanley Kubrick's Full Metal Jacket. He was also in Birdie. He was in Netflix's Stranger Things. He was in And the Band Played On, that film about AIDS. And he was even in Vision Quest. That's a film back from the blast from the past. Essential Cinema, it's a really great program. We just did it last week, our first one. Got a lot of great responses. We're interested in the aesthetics and the cultural significance of films that we consider to be essential viewing. So that's going to be on June 3rd. Also, if you know aspiring filmmakers, one of our more popular programs is the International Short Film Competition. We have our call for entry starting now. It's our 8th annual. We hopefully we'll be able to hold it live because we have a red carpet, and we hand out the FOLCS Award. This is for aspiring young filmmakers. These are films 20 minutes or less in any genre on films dealing with social justice. It's really, go on our website, go to our film festival, and you'll see highlights from last year's and actually all 7 prior years. It's one of the more interesting, fun things that we do. So please tell your friends if they're aspiring filmmakers to submit to the International Short Film Competition and participated in FOLCS awards night. And finally, look, you know, if this is your first time with us, make sure that you're on our mailing list. Go to folks.org because our programming isn't going away. Yes, we've gone digital. Yes, we have a digital presence, but we've actually ramped up. We're doing more, and we're really happy with this model, except for that little mess up before when FaceTime just eliminated, I couldn't get it off the screen. So that was a glitch that you all watched us, and hopefully we'll fix that for the next time. So we'll see you on June 3rd. I want to thank our guest, Ben Sheehan. I want to encourage you to get his new book, Oh My God, WTF. I won't say what that is. Does the Constitution actually say? Ben, thanks so much. You were really a wonderful guest.
Thank you so much for having me. And I love what you all do, and honored to be a part of it.
Thank you, Ben. Good night, everybody.